Good evening, everybody, and welcome to the Thursday night seminar with Fletcher Day. And tonight is the latest in Mohammed Haque's series, Adjudication Matters, and he'll be talking about enforcing and challenging a decision. So welcome, Mohammed. As always, if you have questions for him, you can enter those in the Q&A or chat facility in the bottom toolbar there, and he'll endeavour to answer as many of those as possible at the end. Additionally, if there's something you don't wish to answer or ask, in an open forum, you are perfectly welcome to email him. You can see his email address there on the screen, mohammed.haque@fletcherday.co.uk. As always, he's happy to answer any queries by email. Okay, without any further ado, Mohammed, I'll hand over to you to start proceedings.
Thank you, Julie, and thanks to all of you who are attending this wonderful evening. I know summer days are going thick and fast, but yet you have taken out time to listen to my boring lectures. That's a good sign. But anyway, it's important as well. Although it may not be as important as it is this evening, I'm saying, on the things or topics you've covered earlier or we're going to do later. But this is nevertheless a very important part. I'm going to discuss the steps roughly to either enforce, if you're the winning party, or challenge a decision of an adjudicator. So we have started with our journey with what is adjudication and how do you start it, and the notice, the referral, the response, the further submissions by the parties. Now, finally, we have also discussed the decision itself, how it looks like, and all these, and also jurisdictional issues and natural justice and all. Now, 28 days or 42 days or any other extended period, adjudicator has issued its decision. And some people who are new to it, they think that's the end of everything. Not at all. Despite the fact that adjudication gives you a decision, but it's quite common for the losing party not to do anything. It's not impossible that the losing party is advised by the professionals that enough is enough. You don't have a chance or a standard chance. But at the same time, it could very well be that the losing party, rightly or wrongly, believes that the adjudicator made a mistake. He was not correct in making the decision, and then they say, we just refused you to pay. This is one of the ironies of the ADR, that if you have a court order in your hand, then if you do not comply with it, the sanctions are so heavy that people do not often take the chance, you see. So that's the historical reason sometimes people think that, I better go to the court. However, the costs of a civil litigation sometimes are so high. And compared to that, although costs are not recoverable, party costs, I mean, under adjudication, the overall cost is so less to get a decision of the adjudicator in even a major dispute involving millions and millions of pounds, that it turns out to be better to get an adjudicator's decision. However, as I said, there are parties who still continue to believe that, okay, we will still wait for another round and ask or see what the court does. And today's topic will cover that section or the period or the round where the decision has already been issued, and either a party who has won going to enforce it to a court of law, or the party who lost challenging it. Now, even before we get to that stage, if the adjudication is under the scheme, we know that the parties have an entitlement, which is a very important rule to correct the typos under the slip rule. Do not be lazy, because there might be things which, if you haven't corrected, might cause problem to you when you're enforcing, and maybe you are not going to get enough money even, or you make a particular claim has been not been dealt with adequately as it should have been. So that's your last chance to submit some argument even, following the Paul Jensen case a couple of years ago, that once you open the decision, the adjudicator can even look at the basis of it, although it's not historically the right approach. But Paul Jensen has thought there is no rule which says he cannot, and TCC apparently has accepted it. And there was wide-scale discussions among the adjudicators that possibly Court of Appeal is going to overturn it, but to the best of my knowledge, that has not happened. So slip rule is always important to take into consideration. Be quick to submit a slip rule request, and it's the time expires within 5 days. But one caution though, if you are the losing party, and if you request the adjudicator to correct his decision on slip rule, regardless of whether you are saying on a reserved basis, I have the right to challenge the jurisdictional challenges that I made earlier, it's gone. So make sure, if you are the losing party, don't bother, because you raised that during the enforcement or the challenge proceedings into the High Court. Now, gone, the slip rule period is over now. So we are on the 34th or the 48th day of the cycle, or any other period extended by agreement to the parties. What to do? Well, you can ask and send a letter to the other side, if you're the winning one, that you are bound to pay me now, and the other side might just keep quiet, doesn't do anything. Okay, so that's within their rights. Don't get upset. Rather, if you're a professional attending my talk, please do remember to remind this to the parties at the very outset and in writing, because I've time again experienced it in early days, that I've told them, I've emailed them that, look, you will get a remedy or a decision, but it may not be complied with. However, as soon as the decision is gone, what a champion you are, we won, you've done an excellent job, this, that, the other. And I remind them again that, look, that doesn't mean that the other side is going to pay. They don't believe you. They don't believe you. The parties are like that. And what happens? Then you say, no, Mohammed, doesn't matter. That I met John last night. He was very upset, meaning the other side CEO or the commercial director. I saw his face gone black and all these. So it's like a win of a war, and not like thinking about the remedy they were fighting for or seeking to achieve. And then you say, nevertheless, you make a demand, you send a letter. Sometimes they even do not do it because they think this lawyer is trying to get some more money out of me by sending a letter. But anyway, soon they realize that the letter is sent out, and the other side's lawyer has advised their client that, unless it's been enforced and declared as correct, there is a chance that that might happen. And if you want to take that chance, let's go to the court. They will say. And tactically, they will not go to the court first by starting a declaratory relief that the adjudicated decision is a nullity. They will wait for the winning party to get frustrated and go to the court and ask for the enforcement of the decision of the adjudicator, and then as a defense enter the challenge they have in their bag. So repeatedly telling you, if you're a professional, put that in writing even before you start an adjudication, and also remind the parties always that if you are the losing party, you'll have to bear the cost of the adjudicator. That's the norm. Normally, the adjudicator will impose the cost on you, the entire cost normally. Now, do you know what? you you consult the scheme and try to find out what happens next. It doesn't say anything. It's surprisingly silent. I will mention later on that there is a reference into the scheme, neither the active, of the section 42 of the court's right to go for peremptory order enforcement. But as you will see, it's been said by the High Court of England that that's not the right course of action. People in desperation tried other things. They went to summary judgment. They went to winding up petitions. They went to mandatory injunctions and all sorts of different things. However, TCC has developed a procedure under its TCC Courts Guidance Section 9. And that's the only procedure which is most popular and mostly used. And I'll be discussing it from the enforcement perspective in detail that today. The first case that come to TCC for enforcement was Makeup Engineering, and it was followed in Wales, UK, again against Dahl Jensen, meaning of course Paul Jensen's decision. If you are an adjudication guy, you must be familiar with him. Amy Y Valley, the county of Hertfordshire, and Crillion and Devonport, of course. These are the landmark cases. Wales and Crillion are from the Court of Appeal, and it summarizes the position. And it makes it very clear that the intention of the legislator was to create a mechanism to pay the contractor or the subcontractor. So court felt it's necessary and a duty to enforce the adjudicator's decision under, of course, a Part 7 claim and a CPR Part 24 summary judgment. They extended their hands and they said, always said that we will enforce the decision of the adjudicator unless the party, losing party, can establish to the satisfaction of the court that the adjudicator never had a jurisdiction, and also, or alternatively, the adjudicator was in a material, first the word was used, material, and then a serious breach of natural justice. I'll come back to these two aspects at the end of the presentation because that comes from the challenging party, of course. But courts view or approach both by the TCC and the Court of Appeal, and following Makeup Engineering, of course, TCC decided to develop a procedure, as I've already said, to bypass the lengthy process, a CMC meeting and all these, and cost implications. And generally within 28 days of lodging an application, it's been disposed of, sometimes even earlier if the court finds it's necessary. And sometimes, of course, if complex things are involved, maybe 6 weeks needed, but within that you are done. And of course, whichever party was unreasonable through the process will have the cost order, meaning they have to pay for their own cost as well as a summary cost order as assessed by the justice of the day for the cost of the other side. So these are then actually acts as teeth for the challenging party or the losing party. They start feeling the hit. But till you actually raise the enforcement application, the ball is not set in rolling. So pretty much what you need to do, unless of course there are exceptions where the losing party straightway pay off, or they kind of acknowledge that, or do a settlement discussion and brings it to an end. But in a vast majority of cases, it goes to enforcement proceedings as developed by Part 7 or Part 8 procedures abridged under the Section 9 of the TCC guidance. So how do you do it? Well, if your adjudication, that's theory, if your adjudication is for money, then again, Dyson, Law Justice Dyson, he was the Justice of the High Court then, when he decided makeup, stated that you start a Part 7 claim and you, of course, add a at that time, the notice of application of abridgment was not part of the procedure because the procedure was not developed that time. It was a normal CPR Part 24 summary judgment application. And we'll see later on that there might be a possibility of a default, a judgment in default as well. However, if your adjudication was regarding a declaration, for example, for an extension of time decision you're challenging, that it should have been extended up to such a point of time, then of course you cannot have Part 7 claims, and the theory is you go for Part 8. Now, if you go for a Part 7, it's not value neutral, so automatically you end up paying more court fees. So what has actually been developed in reality, that the winning party just seeks a declaration that the adjudicator's decision is binding and should be complied with immediately upon the decision of the TCC, and that being a declaration itself, so you don't end up paying higher court fees, and then add up the abridgment procedure and Part 24 CPR Part 24 summary judgment claim anyway. So that's from the winning party. Of course, the defending or the losing party, if they're very sure that the adjudicator didn't have any jurisdiction whatsoever, or he was in serious breach of natural justice, what they can do, they can go to the court as well and ask for a Part 8 declaration. Simple. And of course, they will seek a summary judgment as well. So that's more or less the starting point. And what you do to start the claim, and what are the steps that's been followed. I don't know if you can see this very well, but of course you have the slides you can download. This is not my flow chart, make no mistake. This is a copyright issue. You can see at the top of it, it clearly says it's been copied from Practical Law. All the credit goes to them. It's their flow chart. I've just used it for your advantage, and any mistake in it is not my responsibility, as this is not mine either. But following the copyright rules, I'm declaring it clear cut, that, and been written here as well on the slides, that this is not my slide, or this is not my flow chart. So you'll see that there is a preparatory thing. What you need to do at the time you're taking the preparation and lodging the claim, you need to fill up a claim form. And of course, that will include particulars of claim. You have to have an application notice with draft direction of abridgment or for the CPR Part 24. I'll be coming to that in a minute. And then, of course, you have to have evidences, and the main evidence of the the proceedings is a witness statement. Added to it the other exhibits. I will come in a minute to that as well. Now, let me just explain a little bit more about what you include and what you don't when you are filling up the form. Now, whether you are filling up a Part 7 or Part 8 claim form, if you are the winning party, keep in bullet points type thing. Of course, you have to introduce the parties, you have to introduce the contract, you have to introduce the site, you have to introduce the date when the adjudication started, and then say, what was your claim? Just simply not the whole thing again, just simply the remedy you have asked for, and how the dispute was crystallized, and so forth. Do not, the TCC judges, they get very annoyed if you start re-discuss or reclaiming the dispute. You see, this is not a claim. This is simply a declaration that the adjudication's decision has to be complied with. And those are exhibits of your evidence later on. So in your claim form, just this bullet point information, okay? You contract, the site, the provision which allowed you to go to adjudication, if the scheme or any other rules are applicable, where the site was, what the dispute was, as you do in your notice. You know, this was the dispute all about, these are the remedies sought, these are the submissions made, like the referral this day. Sometimes particulars of referrals, particulars of submissions like the referral, the response such and such date, then they reply, they rejoined us, are rejoined us, date and that, and then, you know, the date of the decision, and then refer that this will be coming as an evidence with it. So that's that. And then what you are looking for. Obviously, you have to tell the judge that you're looking for, as I already stated, that although Part 7 claims are more applicable for monetary judgments or awards or decisions of the adjudicator, the practice is you don't want to pay the court fee, so you just simply say that I'm seeking a declaration, you know, that the adjudicator entered the decision correctly, and that should be complied with immediately. That sort of a thing, you know. So more like a declaration and an injunction. So that's that, you know, that's that, your form. And then of course, as you are doing form N 2244, the notice for the CPR part 24 will then seek to the judge of the day. You'll be just adding it because no judge has yet been allocated. So you'll be just like addressing the court that you are, because there is no extra complexity involved in it, and the adjudicator has already dealt with the points of laws and facts been raised. So you are seeking a summary judgment, and you want to bypass the lengthy process involved in normal civil litigation. So what will then happen? Oh, well, the third thing you need to compile is the list of evidence. Again, even very recently, Lord Fraser has highly criticized the practice of some well, some lawyers, of course, because it's High Court. There isn't anyone else other than a lawyer who can lodge things in the High Court. Although you can do in your person, but normally I'm saying he criticized it that, you know, you don't really litigate here, and don't send 100-page long 100-page long witness statement, you know. And mind you, I mean, regardless of Denton's case, okay, where it said that the evidence witness statements should, you know, try to cover up each of the claim. This is what the adjudication business judges are saying, that this is, we're just looking at the merit of the adjudication decision, and the ultimate principle, as I said earlier, that unless you can establish that the adjudicator didn't have any jurisdiction to decide, or he was in a material or a serious breach of natural justice, even if he made mistakes, if he has answered the dispute, if he has decided the dispute, and if he has answered the question even wrongly, but answered the question of point of fact and law as appeared or has been given to him, his decision will be enforced for the time being, because this is not a final decision. It's only a temporary thing. Although, I mean, in reality, if we are in construction, we know that in most cases nowadays, that's the end of the chapter. You don't see another litigation later on. So these are the three things: the evidence, and of course, with your evidence, you at least give the adjudicator's decision, and the other submissions, of course. And it's a regular practice, if it's under the scheme, to add the copy of the scheme and the Acts 1996. So that's all about the evidences we're talking about. And I've discussed about the witness statement as well. So I'll go to the next. Oh, I've already covered these. What documents do I submit? Claim form, in particular for claim notice of application, which, okay, this slide is also done. Now, what will happen once you start the proceedings? How do you start the proceedings? You go to the respective TCC courts registry building. If you are in London, then it's Rolf's building, and you have your court administrators sitting at the ground floor. At least before pandemic, they used to sit. I haven't been there during the pandemic. And all you have to do is just go there, show them that you have the documents, and if you are a solicitor, you know very well, more than me, that how to do that. And you lodge it. And what actually happens, that the chairman of the TCC allocates this case to one of the esteemed judges we have, and normally the judge of the TCC will give the direction without obviously consulting the parties, and also if you did not include a full bundle, I'll ask you to serve the witness statements to the other side as soon as possible, or within a given period of time, 3 days, 5 days, 2 days, because they're abridging the whole thing. So time is important here. And if you fail to serve within the time, you may have implications. But why would you fail? Because it's an important thing. So you should do it within time. Better safe than be sorry. Okay. So they will be. I mean, I've during the pandemic, of course, they're sending it straight away to the parties through emails, and there are administrative staffs who are helping them out to do it. But even if it's a normal thing, you receive an email and also followed by a postal mail receiving on the next day, and you promptly comply. Now, an interesting point I would like to mention at this point of time, that sometimes what happens, the losing party, they simply disappear. They don't even acknowledge the receipt. Don't forget, if the receipt is once you serve it properly, the claim, as you have initiated before TCC, and the acknowledgement of the receipt is returned, you may go for a default judgment if they do not appear or file to indicate that they want to contest the application. A default judgment may be entered. So if you are on the losing side, be cautious. Don't relax anymore, because if I'm saying so seriously, because even very recently, again, Lord Justice Fraser, it was a default judgment was entered, and we all know that a default judgment can be set aside. There's a procedure there, but court's view is very simple. They would say that go and litigate. I'm not going to set aside this judgment, default judgment, because where have you been? You were a party to the adjudication. You have attended the adjudication. You have made a jurisdictional challenge, and when this form has come to you, it was properly served. Why didn't you act properly? So if you are in the losing side, be very serious that you have to. Don't. And sometimes what happens, if you are a solicitor, and if it comes to you, and then or to the party, and they hide, to the losing party, and they try to hide, and then later on they say, I was never told that this is going to happen. Oh, you should have told me, Joe. You didn't do that. Again, cover your back. You are under indemnity insurance threat. So at the time you're starting it happened to me so many times, that the other side made a proposal, a very reasonable proposal, and I've in writing said that, look, this is a very good proposal, so accept it. You have pitfalls here and there. And sometimes what happens before the adjudicator, the party said, we are trying to settle it. And then they go away, then they come back and say, the settlement attempt didn't work. Fair enough. And the adjudicator, if he can sense somehow that this should have been settled, it could be that your lack of something will cause the adjudicator to decide that you are the lost party. And as soon as that happens, the clients come back to you and say, you did not tell me to settle and all this. So you, if you're a professional, don't be greedy, be reasonable. If there is a reasonable offer, advise your client and in writing, and get acknowledgement that they have understood it. Because I go up to that point because I like to be careful, so that after the decision there's no problem. This point is also very important. Let them know that if you receive a court proceedings, do not wait. You have to comply. If you do not comply, then there is a chance that there will be a default judgment. And the court's trend is, TCC trend is, once a default judgment is entered, if you go, they disregard you. They say, no, 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 you don't come and bother us, okay? So as I said it already, that normally the timetable set is within 28 days, but sometimes, if there are complex things, then you may seek extra extension. And by and large, I think almost all the decisions mostly been handed down in 42 days. Now, normally on Friday afternoon, the summary uh, hearing is done. It's about between 2 to 3 hours, and that's it. Some of them even, it finishes in half an hour because judges come very prepared and straight away goes to the point that show me that the challenge has merit in it, meaning that there is a jurisdictional point which doesn't pass the threshold, or the adjudicator is in a serious and a material breach of natural justice. As I said, I'll be discussing it towards the end of my discussion, okay? Well, I've just covered this default judgment and done it. Well, if supposing that the defending party has um, shown the interest to contest, has sent a defense and some arguments, sort of things as well, or any evidence if they do have one or some, because normally you'll be sending the exhibits of the whole of the proceedings to the adjudicator anyway, so there'll be little they can actually add to it, but of course sometimes they give witness statements as well. And especially for keeping cost in mind, their settlement efforts are raised before the judge, so that could be included in their defense too. But in any case, 24 hours before the hearing date, which you will receive the date through the private secretary working for the judge, these days obviously via email first, and then there'll be a letter by post as well. And during the pandemic, it's mostly by electronic transmitting system. And the hearings are, of course, through this distance and remote hearing systems has been adopted by the Royal Court of Justice. So everything is electronically, but even though you might receive postal directions as well. Now, they will, on the day, the judge will come, they will listen to the submissions of the respective representatives. If the parties have appointed one, if there isn't any representative, then if the parties are present in person from the parties, or even both, even if the representative is there occasionally, the judges might sort of ask one or two questions to the, very rare, but to the parties as well. And in a vast majority of cases, I've experienced certain judges are there, and unless there is a very complex issue involved, they just outright give the decision and say, give me the draft order, we'll sign it and let them know. And then, of course, it will be formalized within the next few days, and a brief judgment will do. Sometimes a full judgment is also handed down, but then the order is not been awaited. The third possibility that might happen is, okay, there is a point of fact and adjudicators are not in a position to go to cross-examination and all these detailed procedure to ascertain the facts up to the level and the standard courts do. So what happens that they say, look, this point is so vitally important to the claim that this should go to a trial, and this limited point is then allowed in 2 to 3 weeks time to be contested through cross-examined witnesses, and after that. But other than that, normally, as I said, on the day you get it. But a couple of times I've seen as a party representative that if it involves a very complex point of a law, factually it's not normally, as I just said, they will, if it is something which needs further evidence and which is very demanding and convincing, a quick date is given to submit evidence and cross-examination and submissions. Other than that, if it's a complex point of law, sometimes time is taken by the TCC judge of the day to compile his or her judgment, and then later on hand it down. So then they will give you a judgment day for handing the judgment as well. Now, that's all about that side. Of course, one little thing is there about cost. Now, be careful. First of all, it is a summary cost procedure, meaning that you do not send a cost budget at the very beginning, but on the day of the hearing, final hearing, the judges sometimes say that, okay, this is what you need to send me because I'll be assessing the cost as well. But it's pretty much standard, and you have more or less a set amount you have to have in your mind for the costs. But who's going to pay it? Of course, if by logic, if whoever wins, the other side needs to bear the cost, but that's only a theory. Again, other things are taken into consideration. First of all, a cost is given on an indemnity basis if it's found that the challenging party really never had any basis to continue, and this was taxing on the court's time. So some sort of a penalty type attitude is taken but against that party. It's similarly the same if you are somebody who's received a very reasonable settlement proposal and you have declined it, So despite you won the adjudication and you have the right to enforce it, you may not get a cost order, if you are unreasonable. Mind you, that there isn't any pre-action protocol required for these proceedings. So there isn't any, one of the good reasons for dispensing with this was obviously the reason obviously was that you do not want another mediation, after sending a pre-action protocol. So judges never wanted at the TCC to get the parties forced to another ADR through this pre-action protocol. So it's been historically declared that we don't need any pre-action protocol for these proceedings. The straightway issue it, and we will look into it. So there isn't any other procedure to find out if the winning party is unreasonable, but at the time of assessing the cost, that if there was a proposal made, what was the reaction? And if you have not reacted properly, you might lose the right to get the cost recovered from the other side. Now, that's all. Then we come to the challenge point of it. As I said, there are only two basic exceptions that, excuse me, even if the adjudicator has given a wrong answer, it will be enforced unless it can be shown that the adjudicator in his decision or making the decision, he never had the jurisdiction to decide, or he's in a material or a serious breach of natural justice. So I just wanted to, I've discussed these issues at length earlier, but I'll just remind you some basic principles. For example, if the jurisdictional issue you are talking about, if the adjudicator somehow didn't decide the decision or issue the decision on the 28th day, he issues it on 29th day. On the 29th day, there's only one reported decision on it where adjudicator was allowed because he's had a genuine problem. He decided late in the afternoon and he had a computer crash or his internet didn't work. But the decision was shown to have been done on that day. Now, I personally feel, I being an adjudicator, that what I do, I take the phone numbers, the mobile phone numbers, at least of the party representatives, or one of the members of the ultimate party. And just in case, one of my tutors, actually, I think Chris Linnett told me this, that this is a very good practice. If you're an adjudicator, you must take note of this, that take the phone number and the mobile phone number out of our phone number, and then take the picture or an image of the first title page of the decision, text it to them and let them know that this is a problem. You are failing to email it because of some technical issues. Because the TCC said that, and very recently Lord Justice Colson said in an extrajudicial, I think in the Society of Construction Laws seminar or yearly lecture, the adjudicator needs to be bold, you adjudicators, do the best and we will support you always. So if you do the best, if you have the phone number, if you can reach them, if not by sending via email, at least over phone and anything, that you have done the decision, but you're struggling to send it because of some problem, then there is a decision by the TCC that they will accept. Other than that, if you have delayed to reach your decision, no one can help you. You know, if you're an adjudicator, if you've decided your decision on the 29th day, now if you are the losing party or anticipating that you're going to lose, what you do is immediately issue another notice, another intention to adjudicate the decision, the dispute once more. As soon as you lodge it, the whole of the adjudicated decision becomes a nullity. So if that's that happened, then that's a serious breach of jurisdiction. Similarly, if the referral didn't come within 7 days, okay, of the date of notice, if scheme is applicable, if the notice was not given to the responding party before you apply for the nomination of an adjudicator, these sort of things will go to the core and will not save. If there was a procedure involved, like a named adjudicator or a list of adjudicators or a particular body, and you went to a wrong body, a wrong nominating body, no one can save you. No one can save the adjudicator's decision. If you are a party representative, these are the things you have to look at first. If the scheme applies and you've gone on to something else, no one can help you. You know, and it's not an argument that they didn't raise the objection. It's not even an argument like that. There doesn't exist an argument like this. A nullity is a nullity. So only those sort of situations in jurisdictional. And then natural justice, again, you know, as soon as you come to know that there is a breach, you have to raise it. Okay. I give you an example of jurisdiction type, very latest one. And I actually went through the similar situation again, and that was been rejected by Her Lordship's, I forgot the chairman's name, Fiona O'Farrell J, very recently in one of my adjudications. It actually happened twice this year. Motorcar's case, what happened, Fraser Lord Justice rejected the challenge, where, mind you, there was a contract. One of the parties Italian, the other party was from maybe Spain or France, I forgot. Okay. Now, the contract says the proper law of contract is not England. Okay. The arbitration clause says you have to go to ICSID or ICC, whatever. Now, one of the parties started an adjudication. Adjudicator took the jurisdiction and took the view that he has the jurisdiction. He decided the matter. And then the losing party went to the High Court. Federal Law Justice, refusing the challenge, stated that, look, adjudication's jurisdiction comes from what? From the scheme and the act in the scheme. And the act in the scheme both says, provided you have a construction contract, provided the site is in England, adjudication is available to you. It doesn't matter that the proper law of contract were elsewhere. It doesn't say that the proper law of contract has to be there. A similar situation I had in an unreported decision that I refused the challenge to my jurisdiction, and they went to TCC straightway, interim, before even I issued the decision. What actually happened, they had a litigation, and which was not finally decided through a trial, where the claim was struck off. 4 claims were there. And they now came to me with adjudication, and the defending party, of course, or the responding party before me, was trying to say, that was no permission was granted to restart. So that's an abusive process under Denton's case, and you do not have a right to proceed. And I said, look, my jurisdiction has come out of course, following Motorcast. I couldn't say Motorcast because no one has referred that case to me. But my jurisdiction has arisen from the scheme, not from the civil code. And there isn't anywhere into the civil code or the judge who rejected it has ever said that I can't. So I will simply proceed. And they went to the TCC to injunct me permanently. And the High Lordships, Farrell J, in their first hearing within 3 days rejected it. So that's the kind of attitude the TCC has to support the adjudicators. Remind you, this is a cash flow issue, and all of us know how important cash flow is in construction. So you want to be awkward, you will face the music. That's the message. Be reasonable, go through your process, you're going to win. So, of course, as I've stated, the recent trend of the decision, and one more thing we have to keep in our mind, and more than one decision actually referred to it expressly. One of such situation is if your adjudicating party suffering from insolvency, and Federal Law Justice on the same day when the Briscoe and Lonsdale Electrical was been delivered by House of Lords, we're dealing with that case. And he said very clearly that if you are coming to me after so many months or even years to do an enforcement, then I'm sorry, I'm not going to go for a summary judgment. I will go for a full hearing. Having said that, he also said, I can see why it has happened. It's happened because of the Briscoe case, and the Briscoe and Lonsdale is now in the House of Lords or UK Supreme Court. That should be properly so said, and we'll have to reconsider the matter after the Briscoe and Lonsdale. We're yet to see a precedent. I'm a poor adjudicator. I cannot predict what the law is going to be till something is decided by the higher court. So I will not comment on that. But do not get excited by either of these 2 decisions. Just similar, another note of caution. I discussed the Motorcast case earlier as well, and also in my law update, because it's an April case of 2021, that this is the first case which involved an international arbitration convention and jurisdiction clause. And earlier, the rule was, before Brexit, we had a European Union regulation controlling that. Now it's no more there. So how things going to pan out in the context of that is something of academic debate. As I said again, I'm only an adjudicator. I can't tell you what the law is going to be. That's not my jurisdiction. So you may read scholarly articles by the QCs, but don't take any one of these guaranteed till a TCC decision comes. And I think that's all from my side today. Yeah, time-wise also not too bad. Off to you.
That's great. Thank you very
Thank you.
much, Mohammed. And thank you everyone for listening. We don't appear to have any questions, which is good. And the one question that had been pre-submitted, I think you've definitely answered in every way, shape and form. We are next with you for the next in this series, which is on payment adjudication on the 14th of October. So if anyone would like a place on that, please let me know by emailing seminars@fletcherday.co.uk. We also see quite a lot of Mo over the next couple of weeks as he's standing in for several other presenters. So thank you, Mo, for being a totally awesome person. Next week we have CAP, the latest in the conflict avoidance in process, and that's the growth of conflict avoidance. That's Tuesday night. That has Mo, Martin Burns from Ricks, Len Bunton and Lisa Malloy having a discussion about how CAP has grown and how the governments are supporting it. And then Wednesday, we have project security at 8 a.m. and programming and time with NEC and JCT at 6. As I say, anyone who'd like a place on any of those, please drop me an email, seminars@fletcherday.co.uk. We'll book you in. And as previously stated, if you have any queries on anything to do with tonight's topic that you didn't wish to raise in an open forum, please feel free to email Mohammed. It's mohammed.haque@fletcherday.co.uk, and he will be delighted to assist. Okay, Mohammed, we will let you go. Thank you very much. Everyone else, we look forward to seeing you again soon. Have a great rest of the week, everyone. Bye-bye.
Off and on again and again.
A lot next week and the week after.
Holiday time. Anyway, thanks very much for listening. Bye-bye.